Hello everybody and welcome back to Jurisprudence for the Law Academy. As a quick introduction, if you want to support this project and get access to additional content and materials, please consider becoming a channel member. This is allowing us to essentially keep producing the content that we love to do and to teach law in the way that we love to do it, and to make sure that all of this content is free and available for everybody. Alternatively, if you want to make a one-off donation, please consider the super thanks option under the video. This video specifically is going to be talking about some more sociological theories of law. Specifically, we're going to be talking about the concept of law and the ideas of law as encapsulated and as contextualized by the sociologist Emile Durkheim. So, the last lesson, we talked about the way in which Karl Marx analysed law within society, talking about Marxist and socialist theories of law. Again, we didn't do that much detail in terms of the real in-depth analysis that Karl Marx attributes to law, especially given the fact that Marxism is more than just Karl Marx and Friedrich Engels. It is people like Rosa Luxemburg, and then we start to get into some of the more legal-oriented scholarship on Marxist theories of law, Marxist theories of international law. All of which we might do a series of videos on in the future, looking specifically at Marxist theories of law, which I believe would be quite interesting. But fundamentally, we took an overview to Karl Marx's conceptualization of law within society. This lesson is going to look at another sociological theory of law, this being the sociological theory developed by sociologist and key thinker Emile Durkheim. So, as a basic introduction, Durkheim was a sociologist who supported the concept of functionalism, a functionalist within sociology. Now, for those of you who have studied sociology, you'll be amply familiar with Emile Durkheim. Some of you may have done sociology at A level, for example, and now have come up to do a law degree, an LLB at university. So some of these things you might be already familiar with. But fundamentally, Durkheim was a sociologist who supported this idea of functionalism. Functionalism is something known as a structuralist sociological theory, which means that what they do as a structuralist is to examine the nature of structures within society and the ways in which institutions and structures essentially hold societies together and hold the functions of societies together as well. And so really from this idea, and from this idea of structuralism and this idea of functionalism as a conception of structuralist sociological theory, you can really start to embed Emile Durkheim's understanding of law in these same ideas. And so the result of which is that Emile Durkheim argues that law plays a crucial role in this idea of social cohesion. Again, being something of a structuralist theory, examining the nature of structures within society and examining what holds societies together. Essentially, one of the answers to this question, what holds societies together, according to Emile Durkheim, is a theory of law, and law itself, a crucial role in the maintenance of social cohesion. What Emile Durkheim suggests is that as society, develops from religion to secularism, as it shifts away from religious conceptions to secular conceptions, law becomes less of a tool for punishment and more of a tool for remedy and compensation. Now, fundamentally, one of the things that's quite interesting is that when we examine sociological theories like religion, law plays a key role even in that part of society as well. When religion was the key and dominant construction of society, when you had Catholicism, for example, in the medieval period of English society and European society, canon law and the law of the church was something that essentially regulated society in the similar way that religion regulated other parts of society. And so this shift away from religion to secularism shifted the role that law played as something of a religious conceptions of law, to more secular conceptions of law. Law becomes less of a tool for punishment and more of a tool for remedy and compensation. Because Durkheim was what is known as a consensus structuralist, he argues that law and punishment play a significant role in the expression of moral attitudes, which is something of, if we were to attach theories of the criminal law, is something of a legal moralist conception. for those of you who have gone through our lessons on the criminal law, we spent a little bit of time talking about theories of criminalization, and one such theory of criminalization is this idea of legal moralism. Fundamentally, the study of criminalization, at its heart, at least one of the key questions and the key understandings that you have to really think about when we talk about criminalization is, how do we justify criminalization, given the fact that the criminal law fundamentally restricts somebody's ability to do a thing, and if they do that thing regardless, you are then restricting their freedom in some way, either through prison sentences or even through fines and things like that. Given all of those things, given the restrictive nature of the criminal law, the decision to criminalize some kind of conduct, the decision to make something criminal, is something that requires a particularly heavy justification. One of those justifications is this idea that criminalization can be justified on the basis of promoting moral attitudes and promoting morality. Fundamentally, a thing is criminal because it is immoral. And so as a result of that is we can criminalize it on the basis that it is violating some fundamental maxim of morality. Okay, Durkheim, being something of a consensus structuralist, would somewhat support this position, at least when we talk about his conception of the criminal law. Of course, his sociological theory of law is a bit more all-encompassing, because he suggests here that law is an expression of moral attitudes, and so as a result of which, criminalization can be justified on the basis of expressing moral attitudes. Durkheim distinguishes in his sociological theory of law between what he calls a mechanical solidarity and an organic solidarity. And really what this means is mechanical solidarity or mechanical society is something that exists within more simple societies where there is a uniformity of values. And then societies of this nature are considered to be more collectivist. There is less individualism. And this is again something that is expressive of simple societies, of earlier societies, of smaller societies, where there is less room for disparity in ideas and disparity in beliefs and disparity in moral consensus. Instead, there is collectivity in these ideas. There is less individualism in these ideas. The more advanced and complex societies have a higher tendency of individualism. They have a higher tendency of disparity in terms of various different beliefs and moral attitudes. And so Durkheim suggests that our understanding of solidarity is reflective in our nature of the law and how we are to understand the law. In relation to specific elements of the law and specific elements of the legal system, according to Durkheim, the existence of crime, for example, the concept of crime not necessarily in the context of the criminal law, but the context of crime as a thing that happens in sociology, a sociological understanding of crime, is just a normal part of society, and it is also something that is integral in society. Fundamentally speaking, every single society has crime. How we are to define crime is really up to criminologists and up to philosophers of the criminal law, but fundamentally, assuming that we can come to some kind of consensus as to what crime fundamentally is, according to Durkheim, that thing that we have defined as crime always happens, and it is part of a normal functioning part of society. And so because crime is so closely connected to social values that is expressed in a collective moral conscience. Again, remember, consensus structuralism, something that Durkheim suggests is something to do with moral attitudes and an expression of moral attitudes. When something contradicts the moral conscience, it becomes a criminal offence. So very much conceptualizing himself as a moralist in this regard, okay, suggesting that really what happens is that the moral conscience, the contradiction of the moral conscience, the violation of the moral conscience comes first, and the criminal offence comes second. And so fundamentally, we have a sort of collective understanding of what morality ought to be, a collective moral conscience, okay? There may be disparity and distinction on the towards the edges of these ideas, so fundamentally we can all essentially conclude in a society and agree on certain moral maxims and moral values. So for example, we can all probably agree that murder is wrong. This is a core component that most people agree with. The reasons why that is the case is, of course, something that we often differ depending on what kind of normative ethical theory everybody ascribes to, but all of them seem to come to the conclusion that murder is wrong. So if you're a utilitarian, or an act utilitarian, or a rule utilitarian, you will come to the conclusion that murder is wrong. If you're a deontologist, a Kantian, you would say the same. If you were a virtue ethicist, a situation ethicist, etc., 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 you all come to the conclusion that murder is wrong. And so when somebody contradicts that basic moral virtue, then it becomes a criminal offence, i.e. something like murder. And when I say that we can all agree on some of the core components, things that are blatantly obvious, but then we can come to disagreements, and there are disparities when we have a look at some of the more complex, more edge cases. So things like abortion, euthanasia, certain elements of sexual ethics that obviously intersect with religious beliefs, all of which are far more debated, and then the extent to which they can be considered to be a criminal is a far more philosophically interesting conversation. But this is what makes an act a criminal act, a contradiction of moral conscience. And then in this similar vein, what Durkheim suggests is, just like with crime, the idea of punishment is an essential concept within society. Not only is it an essential concept in society, but by extension of the fact that punishment is something that comes after somebody's commission of a crime, it is an essential concept of the crime itself. When an act is considered a crime, it upsets the collective moral conscience. And so the state steps in to make that moral conscience right, to make right the wrong that had been committed by applying a punishment to said crime. And so in this sense, you can come to some kind of conclusions as to how Emile Durkheim understands the purpose of punishment. It is seen to be a thing that comes in to try and rebalance the disparity that exists as a result of the upsetting of the collective conscience. And so the result here is that we can understand punishment theory through Durkheim's perspective as well.